This begins part 4 of chapter 5, addressing civil rights. This is the next to the last chapter. Next to the last portion, I should say, not the next to the last chapter. There'll be many more chapters past this. As previously mentioned, this particular part of chapter 5 addresses different groups that were discriminated against other than African Americans in the history of our country. The first one that I want to deal with has to do with gender discrimination. I'm sure you'd noticed that in some of the previous sections I've mentioned that changes were applied to the male population but not to the female population. In fact, in 1848 at the Senecta Falls Convention, which was organized by Lucretia Mott, a Quaker, to bring to light the issues about women's rights. In 1978, Susan B. Anthony and Elizabeth Cady Stanton drafted an amendment, and it was first introduced in Congress in that year. 41 years later, in 1919, the Congress passed the amendment and submitted it to the states for ratification. It was ratified within 1 year. The 19th Amendment granted women the right to vote in federal elections. The amendment was the culmination of the women's suffrage movement in the United States, which fought at both the state and national levels to achieve the vote. It effectively overturned Minor versus Happersett, in which a unanimous Supreme Court decision ruled that the 14th Amendment did not give women the right to vote. Consequently, then, Congress passed the 19th Amendment, which then did provide women the right to vote. As you can see, civil rights for women continued to accelerate in the 1960s. However, the Equal Rights Amendment fell short of its ratification in 1982. Chief Justice Burger's court, who was involved in a number of later cases, as you will see, applied immediate scrutiny to gender discrimination cases and brought them before the court in an expeditious manner. The ERA legislation was originally written by Alice Paul, and in 1923 was introduced to Congress for the first time. In 1972, it did pass both houses and went to state legislatures for ratification. It failed to meet the mandated deadline set by Congress. Unfortunately, the state of South Carolina was one of the states that did not ratify it. What is interesting, going back to the Lilly Ledbetter case that we discussed in the previous section, was that Congress changed the law because it was outraged at the 5-4 decision that led to the Lilly Ledbetter Fair Pay Act of 2009, in which Title VII of the Civil Rights Act was to reset the 180-day clock, as previously mentioned. What is interesting about the actions of Congress was this was an action that had impact to the private business sector as well as the public. Given that Congress was held by the Republicans, that they would take such actions is interesting. What is interesting about discrimination dealing with Latinos and Asians was a 1946 federal court case that challenged racial segregation in Orange County, California schools. In its ruling, the U.S. Court of Appeals for the Ninth Circuit met in total, not as a panel, and upheld a LA federal court case that the segregation of Mexican and Mexican American students into separate Mexican schools was unconstitutional. As a result of this ruling, Governor Earl Warren of California signed into law the repeal of the remaining segregationist provisions in the California law. Chief Justice Warren would later preside over the Brown versus Board of Education case. In Lau versus Nichols, it was a civil rights case that was brought by Chinese American students living in San Francisco, California, who had limited English proficiency. The students claimed that they were not receiving special help in school due to their inability to speak English, help which they argued they were entitled to under Title VI of the Civil Rights Act of 1964, because its ban on educational discrimination on the basis of natural origin, finding that the lack of linguistic appropriate accommodations effectively denied the Chinese students equal education opportunities on the basis of their ethnicity. The U.S. Supreme Court in 1974 ruled in favor of the students. Status of Native Americans is one that still brings a great deal of quandary to me individually. As you can see, the Constitution leaves the status of Native Americans unclear. Legislation in 1924 granted citizenship to all those born in the United States. The Indian Reorganization Act of 1934 was an early step in bringing self-government to Native Americans. In the 1950s, Congress passed legislation to have Native Americans assimilated and to terminate the special relationship, i.e. to end the legal status of many tribes. However, the failure of termination became obvious by the 1960s, in which, of course, there are few tribes but still have special legal status. The Indian Rights Act of 1968 gave Native Americans much of the Bill of Rights that Indians on reservations had not had. The Self-Determination and Education Assistance Act of 1975 provided even more autonomy, and of course there is no state regulation of gambling as designated in 1987. However, states continue to use zoning issues to minimize possible gambling opportunities, as we have seen here in the state of South Carolina. The American Disabilities Act, ADA, passed in 1990, guaranteed equal rights and accesses to businesses. This involved both employment as well as people accessing these businesses, which of course resulted in numerous construction requirements that have had to be implemented since the 1990s. The Age Discrimination Act in employment prohibits discrimination by employers with more than 20 employees. This involves persons age 40 and older. The gay rights movement, including gay marriage, has become one of the most important contemporary flashpoints for civil rights. The issue of gay marriage has cut across a number of issues dealing such as federalism issues, such as should one state be allowed to not recognize a legal gay marriage from another state, to civil liberties issues such as the right of privacy in Bowers, which we will discuss in a moment, and there are equal protection rights in terms of discrimination. Thus, as you can see, this issue of sexual orientation and the gay rights movement in search of civil rights is a difficult one at best. The military, who have been mainly responsible as an institution for leading the fight for desegregation, had previously a policy of don't ask, don't tell as a beginning process of recognizing, yes, there were gays in the military, but as long as no one asked, they didn't have to tell. That has been, of course, recently repealed, and now the military, at least officially and legally embraces gay individuals within the military. As I suggested, there have been a number of cases that have impacted the process of the gay rights movement. One of the early ones was Bowers versus Hardwick, which was a Georgia case before the U.S. Supreme Court. The court upheld the constitutionality of the Georgia sodomy laws. The second case, Romer versus Evans in 1996, prohibited discrimination, however, based upon sexual orientation. That case was followed then by Lawrence v. Texas in 2003, which overturned Bowers. The Texas case struck down the Texas sodomy laws and found unconstitutional 13 others. While Congress has gotten involved in this process, particularly as it relates to gay marriage, Obergefell versus Hodges banded state-level bans on same-sex marriages, which has, of course, continued their movement towards full civil rights. Affirmative action is a program that is set up to redress historic injustices committed against special groups by special efforts to provide members of those groups with access. As we will see in the next chapter, that the next section, that there are cases that are beginning to examine the actions of affirmative action. This concludes part 4 of chapter 5.